Hey guys, welcome back to the channel where I cover missing persons, unsolved cases, crime news, and more. Well, most of you guys know by now that the final judgment did come down the end of last week. It finally got posted on the clerk's website, the clerk's site on Friday. It finally completed the upload, the final judgment in the family court case of Boone versus Boone. And as much as it gets a lot of technical stuff, I'm going to go through it. Some of you may have seen it, already gone, watched if you watched Tanika's Two Cents or any of the other channels. But I figured we would go through it here as well because a lot of you have been waiting for that. And also this week, there will be there's like a couple new calls from the Boondoggle tapes, so we're going to go through those this week as well. So without any further delay, let's jump right into the final judgment by Judge Jackson. So this is the final judgment, like I just stated. It's long, so it's 17 pages, so buckle up. I'll do my best to get through it. It does get, like I said, a little bit crazy, but it does seem it came down to a little bit of a spoiler warning if there's such a thing in this sort of situation. It seems like the judge made it pretty even for Brian. So, except for the visitation situation with Elle with their son, it seems like Brian is he got pretty much everything that he asked for and he wanted. So there you go. Brian C. Boone versus Sarah K. Boone. Supplemental final judgment on modification and relocation. This cause having come on August 25th, 2025. Wow, has it been that long ago? Yeah, it's been a while. For consideration of petitioner father Brian Boone's supplemental petition for modification of final judgment, modification petition filed on April 12th, 2022, and verified petition to relocate relocation petition filed on February 14th, 2023, and respondent mother Sarah Boone's motion for contempt filed on April 11th, 2023. The parties have appeared, and the court, having reviewed the court file and being duly advised, the premise finds and orders as follows. Remember, these cases also take so long because, there's so much going on in the family court system. 1. Petitioner seeks modification of the parties' final judgment and relocation to Gainesville with the minor child. 2. Petitioner's modification petition is granted in part, and petitioner's relocation petition is granted based on the following. 1. Modification petition. 3. In his modification petition, petitioner seeks a modification of shared parental responsibility for the party's minor child, the termination of alimony, the termination of child support, and attorney's fees and costs. See modification petition, and that's referenced. 4. On June 15th, 2018, the court entered a final judgment of dissolution of marriage, final judgment, and adopted the parties' marital settlement agreement, MSA, and parenting plan, hereby as parenting plan, that were filed on May 9th, 2018. See final judgment, and of course everything is referencing something further in, so that's the way these usually all work. 5. The parties were awarded and shared parental responsibility for the party's minor child, redacted Boone, and of course all his information is redacted, and petitioner was ordered to pay monthly child support of $100 and durational alimony of $1,000 per month for 84 months. And it's also referencing seeing the final judgment, which we'll get to at the end. 6. In his modification petition, petitioner alleges the final judgment should be modified due to a substantial change in circumstance. To wit, respondent, quote, was arrested and charged with second-degree murder of her boyfriend, unquote. The party's minor child, quote, has lived exclusively, unquote, with petitioner since respondent's incarceration, and respondent, quote, does not have the financial need for alimony or child support, unquote. 7. Respondent filed a 9-page handwritten response, modification answer, on May 16, 2022, generally denying all the petitioner's requests for modification rather than responding to each paragraph of the modification petition. A. Substantial change in circumstances. 8. It is undisputed that respondent has been incarcerated since February 25th, 2020. Subsequent to the filing of the modification petition, respondent was convicted of second-degree murder and she was sentenced to life in prison. 9. It is also undisputed that since respondent's incarceration in February 2020, respondent has not exercised any regular time sharing. See Florida Statute 561.30, 11C. A parent's failure to regularly exercise the time-sharing schedule set forth in the parenting plan shall be deemed a substantial change of circumstances for purposes of modifying the child support award. Emphasis added. 10. In anticipation of the entry of the original final judgment, respondent made financial disclosures averring that she was receiving unemployment benefits and in search of a job, and she alleged $5,293.83 in monthly expenses, leaving her with a financial deficit of $4,521. And respondent's financial affidavit, 2018 financial affidavit, filed on May 9th of 2018. 11. Undoubtedly, neither party contemplated respondent's arrest and incarceration when their MSA was entered and their parenting plan was agreed upon. 12. The court finds that at best respondent's reasonable monthly expenses since incarceration total $145. See respondent's financial affidavit filed on May 30th, 2025 at page 8. 13. As such, substantial competent evidence supports petitioner's claim of a substantial change in circumstances. See Hembree v. Thomas, 906 Southern 2D 321, Florida 1st DCA 2005. Finding that incarceration clearly constituted a substantial change in circumstances. Nagel v. Nagel, 286 Southern 3D 377, 379 through 80, Florida 4th DCA 2019. A key factor in determining whether a modification is warranted is determining whether, after the final judgment is entered, the parties' financial abilities have changed. Now, there is a footnote here, and normally I might skip some of these, but this is some really good information. Let me zoom in. I know it's going to be hard for you guys to read this anyway, so I'm going to try to attach this in some way if you guys want to read it. Here's the footnote as far as Sarah's financial needs while she's, in prison. This amount, the amount of $145, this amount includes $16.67 for clothing based on respondent's admission on cross-examination that the $50 clothing expense is charged quarterly, $15 for medical dental expenses, $70 for hygiene and writing items based on respondent's testimony that the prison does not pay for basic hygiene items like all-in-one shampoo, body wash, toothbrushes, and toothpaste, and $43.33 based on testimony of a $5 cost for a 30-minute call and allocating 2 calls per week. The court does not find credible respondent's testimony that she needs $250 per month for snacks because of her stomach not handling meals properly. You know, Sarah likes to exaggerate. We all know that. Remember when she was in, before her trial, she tried to say, I need medical snacks because, my blood sugar gets low. And she had a specific amount of, how many pieces of candy she needed. And Judge Kranick was like, no. So, and she admitted, it states that, she admitted on cross-examination that the prison provides free breakfast, lunch, and dinner. She provided no competent, substantial evidence of any medical issue resulting in low blood sugar. that would necessitate the need for snacks between her free meals. Further, respondent did not identify to which creditor or creditors she was making payments, and she denied owing the Department of Corrections $50, while mother listed a gifts expense. The court found credible father's testimony that he purchases most gifts for the child on behalf of the mother, and both parties acknowledged that father pays for all calls between mother and the child. Yeah, so Sarah's not being happy with the food. Well, that's not really Brian's problem, basically. B. Parenting plan modification. 14. Petitioner seeks to modify the final judgment by awarding him sole parental responsibility, decision-making authority, and 100% time sharing. 15. At the final hearing, father proposed mother have 1 monthly visit and 1 weekly call with child. Mother objected to father's request for sole parental responsibility, and she requested an unspecified number of phone calls and personal space without interference, as well as 1 to 2 in-person visits for the maximum time allowed, holiday visits, and perpetual cooperation from father. 16. The court has heard the testimony of the parties, examined the demeanor, body language, and overall credibility and ability to show self-insight and awareness of the issues pertaining to shared parenting and time-sharing issues, and examined evidence related to the issue of contested time-sharing for minor children. In determining the best interests of the child, the court makes these findings as to the factors affecting the welfare and interest of the minor child and the circumstances of the family as follows. A. The demonstrated capacity and disposition of each parent to facilitate and encourage a close and continuing parent-child relationship, to honor the time-sharing schedule, and to be responsible when the changes are required. Due to her incarceration and life sentence, mother has been and continues to be unable to honor the time-sharing schedule implemented by the parties' parenting plan and the final judgment. The child was able to have virtual visitation with mother when she was incarcerated at the Orange County Jail, but she has since been relocated to a prison in Marion County. Father testified that he has paid for all telephone calls between the mother and the child. According to father, there are times when the child is visibly upset after speaking with mother on the telephone because of the way the mother talks to the child. Yeah, we all know how Sarah is, and we've seen her messages to Elle. I'm sure he is very upset a lot of times speaking to her. I don't think that surprises anyone. B. The anticipated division of parenting responsibilities after the litigation, including to the extent to which parental responsibilities will be delegated to third parties. Since mother's arrest in February 2020, father has undertaken 100% of the parental responsibilities for the minor child. C. The demonstrated capacity and disposition of each parent to determine, consider, and act upon the needs of the child as opposed to the needs or desires of the parent. The court notes that mother continued to contest the relocation petition and subsequent motion for temporary relocation despite the intense local media coverage of her murder trial, despite the child being bullied in school in Orange County. And of course, it's referencing the order for motion for temporary relocation that looks like it was filed on March 6th of 2023 and entered on April 5th, 2023. And mother did not have an articulable reason why she opposed relocation. She opposed it just because she's Sarah, and she's like, no, because I said so. That's pretty much how she works. D. The length of time the child has lived in a stable, satisfactory environment and desirability of maintaining continuity. Since mother's arrest in February 2020, the minor child has lived with the father 100% of the time. E. The geographic viability of the parenting plan with special attention paid to the needs of the school-age children and the amount of time to be spent traveling to effectuate the parenting plan. The parties disagree as to how many phone calls and prison visits the child should have with mother. Father contends that it is 1 hour, 20-minute drive from redacted and the facility where the mother is currently incarcerated. Mother estimates that it's a 50-minute drive. Well, Sarah, since you're in prison, I don't think you probably have a lot of access to GPS information. However, the court finds father's testimony on the travel time more credible, as the mother has never driven from the father's home to the jail, and mother's 50-minute estimate appears to be a generalization of travel between Ocala to Redacted without taking into consideration of traffic and the actual distances between destinations. That's a nice way of saying she has no damn clue because she's never done it and she doesn't have a GPS. Way to go, Judge Jackson. F. The moral fitness of the parents. Father has raised concerns regarding mother's inability to show genuine and accountability or remorse for her actions that led to conviction for second-degree murder and subsequent sentence of life in prison without the possibility of parole. Everybody will agree with that statement 1000%. G. The mental and physical health of the parents. There was no evidence presented as to this factor. H. The home, school, and community record of the child. The child currently attends high school in Redacted and is enrolled in a biotech magnet program. The school is located 11 miles from the father's home, and father is responsible for 100% of the child's transportation to and from school. I. The reasonable preference of the child if the court deems a child to be of sufficient intelligence, understanding, and experience to express a preference. And A. Now this one here, I'm wondering if L will have a chance at some point to make this one possibly stand up as far as visitations and such in the future, because I mean, he's in high school, he's 14, and before you know it, he'll be 15, 16. And as far as I mean, obviously he's got to deal with some of this till he's 18, but I think that he could probably start making some of these decisions on his own, but he may have to go through getting a guardian ad litem or such in the court. But I think it's very possible that he could have Brian put something in as far as that's concerned. J. The demonstrated knowledge, capacity, and disposition of each parent to be informed of the circumstances of the minor child, including but not limited to the child's friends, teachers, medical providers, daily activities, and favorite things. There was no evidence presented as to this factor. K. The demonstrated capacity and disposition of each parent to provide a constant routine for the child, such as discipline and daily schedules for homework, meals, and bedtime. There was no evidence presented as to this factor. L. The demonstrated capacity of each parent to communicate with and keep the other parent informed of issues and activities regarding the minor child, and the willingness of each parent to adopt a unified front on all major issues when dealing with the child. There exists a vexing communications problem between the parties due to mother's incarceration. Yeah. Father is unable to pick up the phone and call mother to discuss day-to-day parenting and decision-making issues. This makes it difficult for the parties to confer with each other so that major decisions affecting the welfare of the child to be determined jointly and expeditiously. According to the father, he sometimes receives calls from the mother asking him to buy things for the child or yelling at him. Father also testified that he has not received any letters from mother in 4 years. Yeah, you're in prison, Sarah, so it's kind of hard for you to really parent your teenage child at this point, and to have any sort of say in his life, really, And that's your own fault. M. Evidence of domestic violence, sexual violence, child abuse, and child abandonment or child neglect, or evidence that a parent has or has had reasonable cause to believe that he or she his or her minor child or children are in imminent danger of becoming victims of an act of domestic violence, regardless of whether a prior or pending action relating to those issues has been brought. There was no evidence presented as to this factor. And evidence that either parent has knowingly provided false information to the court regarding any prior or pending action regarding domestic violence, sexual violence, child abuse, child abandonment, or child neglect. There was no evidence presented as to this factor. Well, there was during the trial, but that has to do with George, unfortunately, for her. Oh, the particular parenting tasks customarily performed by each parent, and the division of parental responsibilities before the institution of litigation and during the pending litigation, including the extent to which parenting responsibilities were undertaken by third parties. While the final judgment provided the parents were to have 50-50 time sharing, father estimates that mother exercised 30% of the time sharing. He testified that mother's time sharing was sporadic and she saw the child whenever she felt like. According to father, there were nights when he got calls to come pick up the child because the mother had started drinking. Gee, Sarah, we're definitely not surprised by that one. P. The demonstrated capacity and disposition of each parent to participate and be involved in the child's school and extracurricular activities. Due to her incarceration, mother has been unable to participate in the child's school and extracurricular activities, and she never ever will be again. Q. The demonstrated capacity and disposition of each parent to maintain an environment for the child which is free from substance abuse. There is no evidence presented as to this factor. R. The capacity and disposition of each parent to protect the child from ongoing litigation, as determined by not discussing the litigation with the child, not sharing documents or electronic media relating to the litigation with the child, and refraining from disparaging comments about the other parent with the child. There was no evidence presented as to the parties discussing the current modification proceeding with minor child, but mother testified that the father has called her a killer and murderer in front of the child. Well, that's like truth, Sarah. Because you are. You can't change the truth, Sarah. S. The developmental stages and needs of the child and the demonstrated capacity and disposition of each parent to meet the child's developmental needs. The child is 14 years old, enrolled in a magnet program, and involved in extracurricular activities. Sounds like he is thriving with his father. T. Any other factor that is relevant to the determination of a specific parenting plan, including the time-sharing schedule. Father testified that mother has not been involved in any major decisions regarding the minor child. Also, he has no idea how to contact mother to get her input on issues involving the child. He testified that over the past 6 years, mother's calls have been on and off. He described there being weeks of tons of calls, but other weeks with none. He also expressed concerns about mother's decision making, including the circumstances leading to her arrest and conviction for second-degree murder. According to him, he doesn't think she makes good decisions. We don't either. We agree with you, Brian. Notwithstanding his concerns, father testified he does not mind mother giving her input on decisions regarding the child's education, health, and other major decisions, but he believes the sole parental responsibility is in the child's best interest given he believes sole parental responsibility in the child's best interest given the mother's circumstances. Basically, he believes that he should be the one, and I agree. And I think most of us agree with that. 17. Upon evaluating the factors above, it is in the best interest of the child that father shall have sole authority to make major decisions for the child. It is detrimental to the child to have shared parental responsibility for the following reasons. Mother's current incarceration with a sentence of life in prison without the possibility of parole, mother's sporadic calls, and father's inability to call mother to discuss parenting issues. 18. It is in the child's best interest for the father to have 100% time sharing with the minor child. 19. The court further finds that a flexible visitation schedule for mother is in the child's best interest of the child due to his age, current school schedule, extracurricular activity commitments, and the distance between the child's home and the prison where mother is currently incarcerated. C. Alimony termination and modification. 20. Petitioner also seeks the termination of the durational alimony or that the alimony be reduced or at least suspended during respondent's incarceration. 21. At the final hearing, respondent argued that she needs alimony to buy gifts for the party's child and she is legally entitled to alimony. Well, she thinks she's entitled to a lot of things that she's not. However, neither party waived their statutory right to seek modification or termination of the alimony award, and it's referencing to see the final judgment. The alimony amount is modifiable upon a showing of a substantial change in circumstances. The amount of an award of durational alimony may be modified or terminated based on a substantial change of circumstances. 22. The court finds that respondent has zero income due to her involuntary incarceration and that her reasonable monthly expenses or reasonable need has been reduced to $145. Yeah, you're in prison, but you're actually having to pay something in prison. That's why a lot of them work. 23. By stipulation, the court finds that the petitioner's gross monthly income is $5,000 and he has the ability to pay alimony. 24. Because respondent still has a need for economic assistance, petitioner's request for termination or suspension of his alimony obligation is denied. See Florida statute 56108 8A and expressly stating that the purpose of durational alimony is to provide a party with economic assistance for a set period of time following a marriage. See, I still wonder why she still has even any ability to get this, but yeah, that's another part of the conversation. 25. However, petitioner's request for a downward modification of the alimony obligation effective May 1st, 2022 is granted. 26. For the remaining 36 months of the 84 period for durational alimony, this alimony obligation will be modified downward to $145 per month for a total of $5,220. 27. Respondent is entitled to total alimony arrears $20,220. D. Child support modification. 28. The father also seeks the termination of child support retroactive to the date of mother's arrest because his child support obligation was based on the equal time sharing schedule outlined in the parenting plan and on the financial abilities of the parties at that time. 29. It is undisputed that mother stopped exercising time sharing with the minor child upon her arrest on February 25, 2020. 30. After over 3 years of litigation, mother finally conceded during the final hearing that father's child support obligation should be terminated given her incarceration and exercise of 0 overnights. 31. During the final hearing, father testified that the clerk was holding approximately $4,000 in child support payments because the clerk did not have information and or an address to where the child support payments could be made to mother. Mother agreed that such funds being held by the clerk of court should be returned to father. Now this number, this $4,000 number, is really important. It comes into the factor at the end when it gets all the numbers. 32. Petitioner's request to terminate his child support obligation effective February 25th, 2020 is hereby granted. And of course it's referencing another Florida statute. A parent's failure to regularly exercise the time-sharing schedule set forth in the parenting plan is retroactive to the date the non-custodial parent first failed to regularly exercise the court-ordered or agreed-upon time-sharing schedule. 33. The new child support arrears balance is 0 effective April 7th, 2026. 2. Relocation petition. 34. In his relocation petition, petitioner seeks to permanently relocate from Orlando to redacted because of respondent's incarceration for second-degree murder. The child being bullied at school and respondent having 0 overnights over the past 3 years. See the relocation petition. 35. On February 23, 2023, respondent filed a handwritten response, relocation answer, to the relocation petition, wherein she objected to the relocation. 36. Notwithstanding her objection, on April 5th, 2023, the court entered its temporary relocation order, wherein the court permitted petitioner to temporarily relocate to redacted. 37. Respondent continued to contest the permanent relocation and did not stipulate to the permanent relocation until the final hearing. 38. The court finds that the permanent location to redacted is in the best interest of minor child, especially in light of the mother's current incarceration in Ocala. 39. As such, the relocation petition is granted by agreement of the parties. 3. Motion for contempt. 40. Although most of her motion involved respondent writing about her displeasure with the court's ruling permitting temporary relocation over her objection, respondent does state that she is seeking to obtain missed, delinquent, or diminished alimony payments. 41. Petitioner acknowledges that he did not pay $15,000 in alimony for 15 months between respondent's arrest, which was February 2020, and the filing of his modification petition. 42. While petitioner acknowledges that he stopped making alimony payments after respondent's arrest, petitioner testified that he did not pay alimony because after respondent's incarceration, he had nowhere to send the alimony payments. He helped move items from petitioner's apartment upon her incarceration. He paid for the storage unit for her items, and he made $600 worth of direct and or in-kind payments to petitioner prior to the date of filing, including giving respondent commissary money. 43. While the court does not find that petitioner's post-incarceration gestures absolve him from his alimony obligation, the court cannot find an intentional and willful violation of the final judgment under these unique circumstances, including respondent's long-term incarceration, petitioner's inability to make Zelle payments, and respondent's lack of a bank account that she can access. 44. As such, petitioner's motion for contempt is denied, as contempt but granted as to the enforcement of petitioner's $1,000 alimony obligation for the 15 months prior to the filing of modification petition for a total of $15,000. 4. Request for attorney's fees and costs. 45. Petitioner seeks an award of attorney's fees and costs. Specifically, petitioner seeks $12,000 in attorney fees and costs through July 29, 2025, as well as fees and costs for the preparation and attendance at trial. 46. The court evaluates the following factors under Rosen v. Rosen. A. Financial resources of both parties. Petitioner is an out-of-work software developer, but he stipulated to imputed annual income of $60,000. While he owns real estate and has tangible assets, the extent of his liquid cash is $1,306 in a trust checking account. See petitioner's financial affidavit filed on April 25, 2025. Respondent no ongoing monthly income, but she's entitled to $22,220 in alimony arrears. B. Scope and history of the litigation. The initial dissolution proceeding took 197 days from the filing of the petition to the entry of a final judgment. Which included the distribution of real property, equitable distribution, time-sharing parenting plan issues, child support, and alimony. There was little to no activity in the court file from the entry of the final judgment until the filing of the modification petition. The scope of the post-judgment proceedings involved relatively straightforward issues on child support and alimony modifications terminations, as well as temporary and permanent relocation, to which respondent eventually consented after years of objecting. C. Duration of the litigation. The post-judgmental proceedings for which petitioner is seeking attorney's fees unnecessarily span 1,231 days from the date of filing of the modification petition to the final hearing on the relatively straightforward issues. D. Merits of the respective positions. Petitioners raised meritorious issues in seeking the termination and or modification of child support and alimony due to respondent's incarceration for second-degree murder and lack of exercising time sharing. Likewise, petitioner's basis for his request for location, in part due to the media coverage of respondent's murder charges, which led to the minor child being bullied, was also meritorious. On the other hand, respondent's failure to acknowledge a substantial change in circumstances to her objections to the termination of child support and her objections at least the downward modification of alimony were without merit. E. Whether the litigation is brought or maintained primarily to harass or whether a defense is raised mainly to frustrate or stall. After being incarcerated for a number of years, respondent continued maintaining her defense to the modification of child support and alimony even after being convicted of second-degree murder and sentenced to life in prison without the possibility of parole. She finally capitulated to the modification of child support at the final hearing, but continued to contest a financial change in circumstances and argued that she was entitled to $1,000 in alimony. F. The existence and course of prior impending litigation. As noted above, the pre-judgment litigation lasted 197 days versus 1,236 days of litigation. Further, respondent continued to drag out the post-judgment proceedings even after she was convicted of second-degree murder and sentenced to life in prison without the possibility of parole. I like how the judge continues to repeat that life in prison without the possibility of parole, and she goes into it further at the end because you know how Sarah's like, is life really like life? Is it like natural life or what is it? No, Sarah, you're in there forever. 47. Upon evaluating the Rosen factors, the court finds the majority of respondents' defenses in the post-judgment proceedings were frivolous or spurious, which resulted in unnecessary litigation. Unnecessary litigation with Sarah Boone? No. 48. Therefore, petitioner is entitled to reasonable attorney's fees and to provide justice and ensure equity between the parties. 49. The court finds that the $175 paralegal rate and $395 attorney rate are reasonable. 50. Petitioner has shown through contempt, substantial evidence, reasonable attorney's fees in the amount of $11,668 through July 29, 2025. 51. The court finds that 8 hours of paralegal time and 8 hours of attorney time for the preparation for and attendance at the final hearing is reasonable for an additional fee award of $4,560. 52. Petitioner shall receive a credit of $16,228 from the alimony arrears owed to respondent, leaving an alimony arrears balance of $3,992. It is therefore ordered and adjudged that A. Petitioner's petition for modification is granted in part. B. Petitioner's petition for relocation is granted. C. Parental responsibility time sharing. Petitioner and or father shall have sole authority to make major decisions for the child and 100% time sharing with minor child. D. Visitation. I. Beginning May 1st, 2026, mother shall be entitled to 1 telephone call per week with minor child, as well as an additional call on child's birthday, Thanksgiving Day, and Christmas. The holiday calls shall be in addition to the weekly calls, but each call shall be no longer than 30 minutes each unless otherwise agreed upon by the parties. 2. Beginning May 1st, 2026, or within 30 days of the minor child being approved as a visitor, whichever occurs first, mother shall be entitled to 1 weekend visit per month for 2 hours per visit at the Lowell's Correctional Facility Institution Main Unit in Ocala, Florida. 3. The transportation costs for weekend visits shall be allocated to father. 4. All other provisions of the parenting plan approved by the final judgment, not expressly modified herein, shall remain in full effect. E. Alimony modification. 1. Effective March 1st, 2020, petitioner's alimony obligation is hereby modified downward to $145. 2. All other provisions of the MSA approved by the final judgment, not expressly modified herein, shall remain in full effect, including the length of the award of the durational alimony. As a result, petitioner's durational alimony terminated on April 2nd, 2025. 3. Petitioner shall receive a credit of $16,228 for his award of attorney's fees in accordance with paragraph F below. As such, the alimony arrears amount is reset at $3,992. 4. The $3,992 balance of the alimony arrears shall be paid in 7 installments deposited into respondent's inmate trust account. 5. Within 20 days of the entry of this final judgment, petitioner shall apply to be an individual who, pursuant to Rule 33-601.716 of the Florida Administrative Code, is identified on the respondent's automated visiting record. 6. Petitioner shall make the following payments deposits to the respondent's inmate trust account. A. Within 90 days of petitioner being identified on Sarah K. Boone's automated visiting record with a current approved status pursuant to Rule 33-601.716, petitioner shall make payment 1 in the amount of $600. B. On or before December 1st, 2026, petitioner shall make payment number 2 in the amount of $392. C. On or before March 1st, 2027, petitioner shall make payment number 3 in the amount of $600. D. On or before June 1st, 2027, petitioner shall make payment number 4 in the amount of $600. E. On or before September 1st, 2027, petitioner shall make payment number 5 in the amount of $600. F. On or before December 1st, 2027, petitioner shall make payment number 6 in the amount of $600. G. On or before March 1st, 2028, petitioner shall make payment number 7 in the amount of $600. See, I'm thinking that if he can, he should pay all this off as quickly as possible, like this year. Get it over with. All alimony payments deposits shall be made by cashier's check, money order, or certified bank draft payable to correct pay and mailed with a deposit slip by the due date above to FDC inmate deposits, and it gives the address there. G. Child support termination. Okay. 1. Father's child support obligations shall be terminated retroactively to February 25th, 2020. 2. Father is entitled to the return of any funds being held by the clerk of court for overpayment of child support. 3. The new child support arrears are $0 effective April 7th, 2026. 4. The clerk is directed to return any and all funds being held for child support to petitioner Brian C. Boone. F. Attorney's fees. Petitioner is awarded $16,228 in attorney's fees and costs and shall receive a credit of this amount from the unpaid alimony arrears. G. Relocation. Petitioner is permitted to relocate to, and this is not redacted, so I'm not going to read it out loud, to redacted Florida. H. All other provisions of the final judgment, MSA, and parenting plan not expressly modified herein shall remain in effect, full effect. And I. The court reserves jurisdiction to modify the supplemental final judgment done and ordered in Orange County, Florida on the 7th day of April 2026, signed by the Circuit Judge LaShonda K. Jackson. Now, if you look back at all this information, guys, if you look back at all of it, he basically is going to get $4,000 back from Orange County clerk, okay? And then he owes her just under $4,000. So honestly, it kind of evens out. You know what I'm saying? It kind of evens out. The only thing over Brian's head is this whole visitation and calls for their son. Wow, reading that whole thing, that was actually one of the harder things I had to read, I think. I like reading the court stuff usually, but I'm not good with numbers and all that. But again, I think that the judge did, I think she did really well. Most of it is in Brian's favor. And like I said, he's going to get this $4,000 back from the Orange County clerk, and he owes her just under $4,000. So I think he might basically just pay her right away, make sure he's got all of that, record. He does the cashier's check or what have you, and be done with her ass, The only thing that, like I said, the only thing he's got to deal with, he and Elle have to deal with, is those calls and monthly visitation. And I do wonder if it becomes a time when Elle does not want to visit his mom before he's 18, if he has the ability to go to the court and dispute that. But I think he does. I think he's going to have the ability to do that. I mean, he's 14 now. He'll be 15. I don't know when his birthday is, and I know it's listed on there, but to me, it doesn't matter. It doesn't matter. He's in high school. He's thriving, and he's a smart young man, it sounds like. So I think that he can decide some of his own future. And if he decides that visiting his mother in prison once a month is detrimental to his mental health, I'm sure that he can dispute that with the family court. And I hope he does if that's the case. But again, I'm glad we finally got a judgment. It's taken a while. I know everyone's been anxious for it. But I'll tell you what, I think that in the end, Brian came out pretty much everything he wanted except for, you know, dealing with some of this stuff. But he was okay with this, you know, visitations and these calls. So you know, he knew that he wasn't he and Elle were not going to get away with any communication with Sarah. It was going to be down to something. So yeah, what can you do? But let me know you guys' thoughts in the comments. And as always, I hope you have a great rest of the day. And most of all, stay safe.